On April 29, 2026, the Supreme Court of the United States issued a 6-3 decision in a case called Louisiana v. Callais. The decision did not formally repeal Section 2 of the Voting Rights Act. It did something stranger and arguably worse. It left the law on the books and made it nearly impossible to win on. Within 24 hours, the governor of Louisiana suspended his state's ongoing congressional primary mid-vote, with more than 100,000 ballots already cast. Within a week, Alabama filed an emergency petition trying to revive a map a federal court had called intentional racial discrimination. Tennessee, Texas, and South Carolina started moving. The Department of Justice's Civil Rights Division, the agency built to enforce the Voting Rights Act, announced it would now sue states for complying with the Voting Rights Act. I have 3 master's degrees in political science, criminology, and business, and in the next 20 minutes, I'm going to walk you through 5 things. What the Voting Rights Act actually did, what gerrymandering actually is, what the court did to Section 2 on April 29th, what Louisiana did the next day, and where this is going. Sources are in the description. Let's go. Chapter 1. The Law Before April 29th. The Voting Rights Act of 1965 was Congress's response to a system of voter suppression so sophisticated and so explicit it required federal intervention to dismantle. In Forest County, Mississippi, the registrar's office maintained a 21-page literacy test. The questions could be selected at the registrar's discretion. Black applicants were typically asked to interpret obscure provisions of the state constitution to the registrar's satisfaction. The pass rate for black applicants was effectively 0. The pass rate for white applicants was effectively 100%. That was Mississippi. The same system, with regional variations, operated across every state of the former Confederacy. The Voting Rights Act ended it. The Act has multiple provisions. 2 of them matter for this video. Section 5 required jurisdictions with documented histories of voter discrimination to obtain federal pre-clearance before changing any voting rule. The Supreme Court killed Section 5 in 2013 in a case called Shelby County v. Holder. Within hours of that ruling, Texas implemented a voter ID law that had previously been blocked. Other states followed within days. Section 2 was what was left. Section 2 prohibits any voting law or practice that results in the denial or abridgment of the right to vote on account of race. The key word written into the statute by Congress in 1982 specifically to remove ambiguity is result, not intent, not motive, result. If your map's effect was to dilute minority votes, you lost. In 1986, in Thornburg v. Gingles, the Supreme Court set out 3 preconditions a Section 2 redistricting plaintiff has to meet. The minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably drawn district. The minority group must be politically cohesive, and the white majority must vote as a bloc to usually defeat the minority's preferred candidate. If you cleared all 3, plus a totality of circumstance analysis, you won. For 4 decades, that was the law. In 2023, in Allen v. Milligan, the Supreme Court reaffirmed every piece of it. The court ruled 5-4 that Alabama's congressional map likely violated Section 2 by packing black voters into a single district while diluting them everywhere else. Chief Justice Roberts wrote the majority. Justice Alito dissented. 2 years later, the court took Louisiana v. Calais and reversed itself. Chapter 2. Gerrymandering, Cracking, and Packing. Quick foundation, because you can't understand Calais without understanding what map makers actually do. Gerrymandering is the practice of drawing district lines to favor a political outcome. The term goes back to 1812. Massachusetts Governor Elbridge Gerry signed a redistricting bill that drew a state senate district shaped like a salamander. A newspaper cartoonist drew claws and teeth on it and called it a gerrymander. The word stuck. The practice never stopped. There are only 2 real techniques, cracking and packing. Cracking is splitting a community across multiple districts so they can't elect anyone in any of them. Take a city neighborhood that votes 90% Democratic. If you put it all in one district, Democrats win that seat easily. So instead, you draw 4 districts that each take a slice of that neighborhood and combine it with a much larger Republican area. The Democrats are outnumbered everywhere, so they never win anywhere. Packing is the opposite. You cram a target group into a single district where they win by 80 or 90%. They get one seat, but the surrounding districts have been bleached of their voters, which lets the other party run up the score elsewhere. You've used 200,000 votes to win one seat that 100,000 votes could have won. The other 100,000 votes are wasted by design. Smart map drawers use both. Pack where you can't, crack where they're spread thin enough to dilute. Political scientists call it wasted vote analysis, and they've been measuring it for decades. The map drawers know exactly what they're doing. For 60 years, Section 2 was the main legal tool minority voters used to challenge cracking and packing. If your community was geographically compact enough to form a majority in a reasonably drawn district, and racially polarized voting was strong enough to prevent you from winning otherwise, you could sue. And you could win. Now, back to Louisiana. Chapter 3. What Calais actually did. Louisiana has 6 congressional seats. Black residents make up roughly a third of the state's population. By any proportional logic, 2 of those 6 seats should be districts where black voters can elect their preferred candidate. For years, Louisiana drew maps with 1. After the 2020 census, Louisiana's Republican-led legislature passed a new map called HB 1. Same one majority black district. Black voters and civil rights groups sued. In a case called Robinson v. Ardoin, a federal district court found the map likely violated Section 2 and ordered Louisiana to draw a remedial map. The Supreme Court paused the case while it decided Allen v. Milligan. After Milligan came down in 2023, reaffirming Section 2, the Louisiana case resumed. The legislature drew a new map called SB 8, with 2 majority black districts. In the 2024 elections, Louisiana sent 2 black members to Congress for the first time in state history. Then a group of voters who described themselves in court filings as, quote, non-African American sued. Their argument, drawing a second majority black district, was itself racial discrimination, in violation of the Equal Protection Clause of the 14th Amendment. A 3-judge federal panel agreed. Louisiana, perhaps surprisingly, sided with the black voters in defending the map. The case went to the Supreme Court. On April 29, 2026, the court ruled 6-3 against the map. Justice Alito wrote the majority. Justice Thomas wrote a concurrence joined by Justice Gorsuch. Justice Kagan wrote the principal dissent joined by Justices Sotomayor and Jackson. Here is the substance of Alito's opinion in plain English. The court did not technically strike down Section 2. What it did instead was reinterpret Section 2 so narrowly that it almost can't be used. The opinion holds that even when a state is trying to comply with Section 2 by drawing a majority-minority district, the use of race to draw that district triggers strict scrutiny under the Equal Protection Clause. The state can only survive strict scrutiny if it can show Section 2 actually required the district. And to show Section 2 required it, plaintiffs must clear evidentiary hurdles substantially higher than the Gingles framework had ever required. The opinion also brings intent back into Section 2. Alito's words, liability under Section 2 should now be imposed only when the circumstances, quote, give rise to a strong inference that intentional discrimination occurred. Congress amended Section 2 in 1982 specifically to remove an intent requirement. The court has now functionally put it back. Justice Kagan's dissent does not pull punches. She wrote that the majority standard is unprecedented and that the court has, quote, conjured it out of thin air. She wrote that the decision renders Section 2, quote, all but a dead letter. That is not a metaphor. That is a sitting Supreme Court justice telling you the law is functionally gone. Chapter 4, The Magic Words. Here is the move that makes Calais so devastating, and you need to understand it because it's going to define the next decade of American politics. In 2019, the Supreme Court decided Rucho v. Common Cause. The question was whether federal courts could hear claims of partisan gerrymandering. The court ruled 5-4 that they could not. Drawing maps for partisan advantage is, in the court's words, a non-justiciable political question. Federal courts can't touch it. Result, drawing a map specifically to hurt Democrats is legal. Drawing a map specifically to hurt black voters until April 29th was illegal. The catch is that in the modern American South, black voters vote roughly 90% Democratic. The federal trial court in Alabama, in evidence cited in Allen v. Milligan, found that black voters supported their preferred candidates with 92.3% of their votes. White voters supported black preferred candidates with 15.4%. That is racially polarized voting at near textbook intensity. So if you are a state legislator and you want to dilute black voting power, you do not have to admit it. You just have to say the magic words. We're not targeting black voters, we're targeting Democrats. Same map, same outcome, different label. Calais blew this loophole wide open. The opinion essentially holds that if a state can offer a partisan justification for its map, that justification can defeat a Section 2 racial vote dilution claim, unless plaintiffs can prove intentional racial discrimination, which after Rucho took partisan gerrymandering off the table. Is precisely what becomes nearly impossible to prove, because the state can always wave the partisan flag. This is what dead letter actually means. Section 2 still exists, the text has not changed, but between the heightened evidentiary burden, the resurrected intent requirement, and the Rucho loophole, plaintiffs almost cannot win. Chapter 5. Louisiana cancels an election. The day after the ruling, Governor Jeff Landry issued an executive order suspending Louisiana's congressional primary scheduled for May 16th. He invoked emergency powers under state law, claiming the Calais decision created an election emergency because running an election under an unconstitutional map would harm voter rights. By the time he signed that order, more than 104,000 Louisiana voters had cast early ballots. Approximately 42,000 absentee ballots were already in. Mail-in ballots had been sent to military and overseas voters on April 1st. There are several legal problems with what he did, and lawsuits started flying within hours. First, governors do not have the authority to cancel federal elections. Article 1, Section 4 of the United States Constitution gives that authority to state legislatures, subject to federal law. An executive order is not legislation. Second, the Supreme Court has long recognized a doctrine called the Purcell principle, named after a 2006 case called Purcell v. Gonzalez. Under Purcell, courts should not order changes to election rules close to an election because it confuses voters and risks disenfranchising people who have already begun voting. The Calais opinion does not mention Purcell once. The court that has invoked Purcell aggressively to block lower courts from ordering remedial maps in October ignored Purcell entirely when its own ruling caused election chaos in May. Third, the court did something further. The Robinson plaintiffs, the black voters who had won the original Section 2 case, asked the court to delay implementation of the Calais ruling until after the 2026 election, so the existing map could be used. Instead, the Calais plaintiffs asked the court to expedite issuance of its formal judgment, bypassing the standard 32-day waiting period. The court granted the expedited motion. Justice Jackson in Dissent wrote that this expedition was, quote, tantamount to an approval of Louisiana's rush to pause the ongoing election in order to pass a new map. Her words. Multiple lawsuits are now pending. The Louisiana Legislative Black Caucus is suing. Congressman Cleo Fields, whose district was at the center of Calais, joined a separate suit. As of filming, those cases are still moving. Whatever you think about Calais on the legal merits, this part is worth sitting with. The Supreme Court of the United States knew exactly what its ruling would do to an active election. It moved faster anyway. Chapter 6. The Domino Effect. Louisiana is not the whole story. It is the test case. The day after Calais, Alabama filed an emergency petition with the Supreme Court asking to revive its 2023 map. That is the same map a federal three-judge panel ruled in May 2025 was both the Section 2 violation and the product of intentional racial discrimination. The trial court used unusually direct language. They wrote, quote, "Try as we might, we cannot understand the 2023 plan as anything other than an intentional effort to dilute Black Alabamians' voting strength. Alabama wants that map back. Tennessee governor publicly committed to redrawing his state's congressional map. Texas already redrew its map last year, mid-decade, with Supreme Court approval. South Carolina is in motion. President Trump posted on Truth Social that Republicans could pick up, quote, more than 20 House seats from this redistricting wave. The math is plausible. Across the South, there are roughly 19 majority Black or majority Latino congressional districts that exist because of Section 2 litigation or compliance. After Calais, almost every one of them is legally vulnerable. A Republican legislature can now draw a map that dismantles a majority-minority district, claim partisan motive, and force plaintiffs to clear an evidentiary bar the Supreme Court just made nearly unscalable. The Department of Justice's Civil Rights Division has announced publicly that it will challenge the legality of Black and Latino majority districts across the country. The agency that was created to enforce the Voting Rights Act is now an instrument for dismantling Voting Rights Act compliance. Independent analysts at the Brennan Center, Campaign Legal Center, and Democracy Docket have all reached roughly the same conclusion. This could shift control of the House of Representatives by several seats before a single voter casts a ballot in 2026, and it could permanently reduce minority representation in Congress for the foreseeable future. Chapter 7. What can actually be done? I'm not going to lie to you, there is no clean fix. But there are 5 things that work in roughly the order they matter. First, vote in every election, especially primaries, especially state legislative races. State legislatures draw the maps. Most state legislatures are elected in primaries decided by a couple thousand votes, sometimes a couple hundred. The single highest leverage vote any American can cast is in a state legislative primary. If you only vote in presidential general elections, you are voting after the maps have already been drawn. Second, push your state to pass the State Voting Rights Act. 9 states already have one: California, New York, Washington, Connecticut, Oregon, Minnesota, Virginia, New Jersey, and Michigan. State VRAs do at the state level what the federal VRA used to do at the federal level. They protect against vote dilution under state constitutions, which the Supreme Court cannot reach. If you live in a state without one, this is the single highest impact thing you can advocate for in the next 12 months. Third, pressure Congress on the John R. Lewis Voting Rights Advancement Act and the Freedom to Vote Act. Both bills restore federal Section 2 protections and add new ones. They have been stalled for years, mostly because of the Senate filibuster. Call your senators anyway. The roll call record matters even when the bill doesn't pass. Fourth, support independent redistricting commissions. California, Michigan, Arizona, and Colorado have versions of these. Citizens, not legislatures, draw the maps. They aren't perfect, but they do reduce the worst of it. Fifth, pay attention. Calais did not fall out of the sky. The legal theory the majority adopted was floating around law reviews and Federalist Society panels for years. Shelby County was telegraphed. Rucho was telegraphed. The next case will be telegraphed too. Followed the Brennan Center, the NAACP Legal Defense Fund, the Campaign Legal Center, Democracy Docket. They saw this coming. They will see what's next. The Voting Rights Act of 1965 is the most successful piece of civil rights legislation in American history. It survived Mobile v. Bolden in 1980, which Congress responded to by amending the act in 1982. It survived Shelby County in 2013, which gutted pre-clearance but left Section 2 alive. It survived Brnovich in 2021, which narrowed Section 2 in the voting procedures context but not in redistricting. Calais is different. Calais doesn't repeal the law, it hollows the law. The shell is still there, the protection isn't. But the fight isn't over, it just moved. It moved to state legislatures, to state constitutions, to ballot initiatives, to the slow and unglamorous work of turning out for primaries that nobody covers. That work is harder. It is less satisfying than a Supreme Court win. It is, right now, the only road back. If this video taught you something, share it. These are your maps. This is your democracy, and this has been going on for a long time. I'll see you in the next one.